I don't care if you marry her. The decisions that are to be made between you and the mother of this child. And that's not to say you can't have people in your family who will contribute and discuss it with you. But as far as telling you what to do or whatever, or conspiring with you to do something that, the way it makes it almost appear here, you understand that Ashley's out of it.
Yes, Your Honor.
Well, and you wouldn't like it if she had some man telling her what to do about and keeping you away from your child, for example. You wouldn't like that, would you?
I would not.
All right. Step down. And by the way, you can get a keypad put on the outside of your door like I have in my house, and all you can do is put a code in there and it'll open the door to prevent this kind of thing from happening in the future. Did they sell the house? We expect that she's probably going to meet someone and she may end up in a relationship with another man. What I want to ask you is, how are you going to feel when that new man in her life starts telling her how to control your son and how to interact with you? In other words, do the same thing that Ashley's doing in this situation. If the new man comes in, you're going to like that?
No, sir.
You wouldn't, would you?
No, sir.
All right. You understand that you and your wife are the parents of this child.
Yes, sir.
Ashley has no say in this. You understand that? And I'll tell her that if she comes in here to testify. But this is a decision that you...
This past weekend, what did you do to make sure that the minor child had what he needed for Mother's Day?
Wasn't this past weekend, was it? Unless I'm badly mistaken.
Weekend before last.
Yeah.
Time flies when you're having fun, Judge. What did you do to make sure the child celebrated the mother?
I didn't do anything with Bryce with that regard. He did make something at daycare that he gave to his mother.
You've heard your fiance say things to you about hurting Miss Cuff before, haven't you?
Hurting Miss Cuff?
Hurting Miss Cuff, yes.
No.
Okay, did y'all have a conversation about a gun?
I believe you're referring to some text messages about an insensitive joke regarding Miss Cuff and the gun safety course that she took, and her being a bad shot or something like that. It was not any kind of threat and was in a private conversation.
Okay, was it after she had said that she would kill her before Miss Cuff could kill her?
I'd have to see the rest of the context of the conversation.
Okay. You two have engaged, you and your fiance have engaged on multiple occasions speaking negatively about Miss Cuff, haven't you?
We've had some private moments of frustration,
Okay.
but nothing directly said.
Well, and your minor child has been present for some of those conversations, correct?
Not correct.
Okay. And the minor child sees how you treat the mother, is that fair?
I treat her with respect.
Okay. Can you agree with me that you've not always been respectful since the two of you have separated?
I disagree with that.
Okay. Well, was there, I'll get to that in just a second, Judge. There have been multiple occasions wherein you've allowed your fiance to be on the phone calls between you and Miss Cuff, is that correct?
Yes.
Okay. And what purpose does that serve, sir?
At the time, I believe you're talking about prior to the temporary, it was to help me if there was anything that was said, because there was a lot going on. Again, it was a emotionally volatile point in time where a lot of things were being said, and I was trying to focus on executing the call with my son and enjoying him having an enjoyable call. And so I wasn't so much focused on all the other things that were occurring on the call.
Okay, but there were phone calls between you and your wife or your now ex-wife, wherein you had your fiance now be a part of that phone call because your fiance didn't want you to have conversations with Miss Cuff by yourself, did she?
That's not true.
Okay, well, why did she have to be a part of the conversations, all of the conversations?
She wasn't a part of all of the conversations.
Does she know she wasn't a part of all the conversations?
Uh,
Your fiance?
Does she know? Yeah.
Do you have conversations with your fiance wherein you were trying to deceive your wife about where you were and when you were back in February of 2025?
Yes, that was the point of separation.
Okay. In particular, you were trying to think of how you were going to leave your wife and your son and go undetected to go see her. Is that correct?
Which conversation?
Judge, may I approach?
You may.
Start right here.
Absolutely. I'm trying to think of the best approach. I could say I have to be in office and could be there by 7 a.m.
Down here?
She doesn't leave until 7:15, so if I'm work from home, then I'd have to wait until she's out of Dixon and then leave.
And on this date, your wife was taking care of the child, is that correct?
No, I don't believe so. I believe this was a work day where that he would have been at daycare.
It was the very first tab. And they're front side and back side. Careful. Thank you. So she would have taken the child to daycare, is that correct?
That's correct.
Okay. And so she was caring for the child and you were making.
Yes, these never materialized.
I'd submit that.
These are going to be collective, right?
Shortly after you left, FaceTime you, is that correct? Shortly after you left the marital residence.
Which one are you referring to?
Right here. Ms. Cuff,
Yes.
and your child's wanting to FaceTime you, is that correct?
I don't see where you're referencing the FaceTime call that he wants to
Or
FaceTime.
she wanted to call you, I'm sorry. The child wanted to call you?
Where is it?
Down in here, and then you say, what is your response to that?
Can you point me to where that we're talking about the call? I'm not seeing that, ma'am.
Call you before bed and tell you good night. Do you see that?
Oh,
And what was your response?
that I can't answer because I'm on a plane.
What was your response?
You want me to read line by line?
What was your response to your fiance about the request for your son to call you? Starts with the word shit.
That was Shit, I feel like she's using him to do this to me, and I can't answer because I'm on a plane.
Okay. Where were you on a flight to, sir?
Washington.
Asked you to call his mother, would you think that respectful or accurate that to think that you were using her child?
I'm not understanding what you're asking me.
Now, you thought Miss Cuff was using the child to call you.
Yes.
Would you think it that if you reached out to her and she wasn't available, do you think it would be reasonable for her to think that you were using the child?
No, I don't think that she would. I mean, I feel like I'm speculating on what she would think.
Start right here.
She's called me twice and FaceTime 3 times. Apparently you. I'm just reading my messages. Yep, she's using the one thing that she can to try to force me to respond or answer. Oh, I'm fine with that part because I didn't get to spend some time with him, but I'm worried about her using this against me somehow.
So,
Or because I did get to spend some time with him.
so at the time, when you were answering, you were on a plane to Washington, and your only concern was that she might try to use it against you in court.
Was that, I don't know that I read that the same way that you did.
Okay, well, tell me how you read it.
May I see it again?
She will try to use this against me. What does that mean? Does it mean what I said it meant?
I think this doesn't. So, can you ask your question again? I think I understand now.
You were concerned that she was going to use it against you in court because you couldn't answer because you were on a plane to Washington, correct?
I'm not. Was that part of the same conversation, like the same thread,
Yes.
same date? Then, yes.
Okay. And when you were in the hospital with the minor child, do you agree with me, sir, that you considered leaving? Considered it?
The marriage.
No, you considered leaving the hospital multiple times.
I'm not sure. All I know is that I stayed there the entire time until Bryce was discharged.
Okay, well, this might refresh your memory. Right here. In context, was your fiance upset with you about that?
Was she upset?
Yeah, was your fiance upset with you being in the hospital with this guy?
I believe she was upset. It looks like about the subject that was being discussed.
What was your response, sir?
How can I make it better? I won't sit beside her. I want out of this.
I want out of this, so you wanted out of the hospital.
I wouldn't say that I wanted out of the hospital. It was, the context here is that this was a highly emotional part where that it was I had just left, and it was a very, I would say, awkward. She was asking me a lot of questions in front of Bryce about me leaving, and that was uncomfortable.
In the meantime, you're texting with your girlfriend, and your girlfriend's in your earbud hearing everything.
It was until we ended the call. Yes, I think if I leave, she's going to use it against me.
So the only reason you didn't leave the hospital on that day is
That is not correct.
that
I would not have left my child in the hospital. I have been with him. He has had other issues where that he went to the ER another time he had turned blue at daycare, and I was the one that picked him up and took him to the ER. I would never leave him behind like that in an emergency situation or any situation.
Okay. And during this same time frame, she can be in your ear, is that correct?
Your Honor, I know your ongoing ruling from the last time was considering what act statements that are all out of court statements by one.
Nothing I've said has been what the girlfriend said.
Well, I reiterate my ruling that at this point, I am allowing these messages to come in as exhibits because I'm considering his statements in those messages and not the statements of the girlfriend. So I have understood that, as Ms. Duke said, she is simply asking him what he said.
That's accurate. What did you tell her?
We can text, and you can be in my ear. Will that work?
Were you trying to appease her?
Yes. Are you asking during the same time period?
Yes, while you're sitting there in the hospital on March 21st, your fiance, while your child is in the hospital, is that correct?
I believe that's on her side, is it not? And that looks like the towel from my bathroom. That was a FaceTime call with her, but I don't think that that is the date that I
At
was.
the same time? I'll take that one out, Jennifer. At one point while you were in the hospital, still haven't done the CT.
Yes, that. I can only imagine that must have been after we discussed that Bryce would be going home with her.
Okay.
But otherwise, I did have plans to leave that night.
Okay. If you would, please hand that to Ms. Collins. And one of your last statements to her, I let her take him him, meaning your child, if I let her take him, I could literally leave this morning.
Yes, that's correct.
Do you recall what you told her about if you didn't get visitation with your child at that first hearing?
I do not.
Okay. Do you remember telling her that you would move there
That I would move where?
to Washington?
I do not.
Okay.
I said, I wish I could move there or you move here. Correct. Yes, of course. Bryce. My family is here.
And what did you say regarding what you would do with the
I said, hang on, I need to read the thing for context. I said, yeah, I know. Honestly, we could just fly back and let my parents watch the kids.
And that takes you out of the equation, is that correct? Your parents watching the kids?
I believe that was referring to possibly a date night because we only have one kid, so that would have been referring to all three of the kids.
And there was one occasion wherein you planted your Jeep at your parents' house and took their vehicle to the airport to keep Miss Cuff from knowing you were leaving to go to the airport. Is that correct?
My parents would give me their Jeep and then wash mine for me. They washed my vehicle and they've washed hers before too.
Okay. But in your text messages, you disclose why you're doing that. You agree with me? So that you would go undetected
That she would drive by and see my Jeep.
at your parents' house?
Wait, that my Jeep would be at my parents' house?
Yes. Or I'm sorry, your Jeep would be at the house, at your house.
At least until the point that they were going to take it over there.
Was there another occasion when Miss Cuff tried to FaceTime you and you were on a flight? After
I'm
the-
not sure.
After you left your Jeep there?
I'm not sure. Where would you like me to start? At the top? Yes, I had to get right with my parents. They backed off, let me drive their Jeep, so mine is sitting there. When Kayla comes, my mom unprompted asked if there was any way you would go on the cruise in May and we could go together. They actually think the world of you. She said you were really nice.
Okay. And then on that next page, after you had already left and your child was still with your parents, what did you tell the girlfriend?
I'm sorry, say that one more time.
Already left. What did you say on the next page?
Yeah.
Kayla just tried to FaceTime me.
Yes.
Okay. And down at the bottom, what did you say?
I said, do I lie and say I'm there?
Okay. And did you lie and say that you were with Bryce at your apartment?
Yes.
When in fact you weren't, you were chosen.
That is correct.
About subject matter, about what was going on? Is that fair to say, sir?
Yes.
Okay. And did you have a text conversation with her wherein you copied that text conversation, sent it to your girlfriend, and said, "I'm fucking with Kayla"?
Yes.
Okay. Sir, why would you do that when this is the mother of your child?
I believe at the time that I was frustrated with the way that I was being talked to. It was not.
And at one point in time, you reconciled and said, "It sounds like I'm not getting 50-50."
Um, I think at that point in time, do you have the date on this? This was all prior to
It was
the
prior
court,
to I
the
agree. It was
temporary,
prior to April the 2nd. This is around March the 27th.
March the 27th?
Yes, sir.
I'm not sure what I was referring to.
You weren't referring to custody?
Oh, no, I was, that is referring to custody.
Looks like I'm not about to get 50-50, and then what does it say down below that?
Read it verbatim.
Yes.
That's a good question. It sounds like I'm about to get fucked a little bit.
Okay. If you'll submit that to Ms. Collins, please. Or do you allow your child to go to sleep?
No, ma'am. When you say co-sleep, are you referring to, my understanding is that that is sleeping with your child in the bed at night?
Is that child sleeping on your chest?
On the couch, yes.
Okay. Have you allowed your child to sleep on your chest on the couch?
Yes.
Okay. Judge, is that Ashley's child on your chest in that picture?
Yes.
Okay. I'd submit that as part of this. After court on April the 2nd, did you contact your fiance to tell her how it went?
I believe I did.
Okay. And did you tell her that you got that you agreed on something with Ms. Cuff?
I don't recall the conversation as sure.
Read this first one.
Okay. I love you so much. I'm still reading, but I'm out of court and it's over with.
Okay. And then what did you say?
Agreed on something. I haven't figured out if I'm excited or not, but we're going to get a longer stretch together. And we're going to have to be married.
And so on this date, you didn't know if you were excited or not, but you were excited because you were going to get a longer stretch of time to spend with Ashley. Is that correct?
I'm excited to get a longer stretch with Ashley.
Yes.
Sure.
Sorry. Then you tell your fiance that you got a 60-40 schedule, is that correct?
Yes,
Okay, and then you tell her I won't be there this weekend, correct, with a sad face?
that's correct.
Okay, and then you have a crying face, and what do you ask her?
Should I hop on a flight tonight? Um,
Those, no. Is it fair to say that Ms. Cuff has done her best to keep you informed of things going on with the child?
for the most part, there were a couple of things.
Name one.
Shortly after him being released from the ER for carbon monoxide exposure, she didn't inform me that there was supposed to be a follow-up visit with his pediatrician as soon as possible until I was able to get my own copy from the ER of the discharge instructions and realized that he needed to go. And I did the follow-up myself.
Are you saying that she was neglectful in some way?
I'm just saying she didn't follow the discharge instructions or provide me with the details that kept me up to date on what needed to happen.
Were you there at the hospital with her?
No,
Okay, so she had taken care of getting the child. Where were you?
I was in Washington.
Oh, okay. So that was it was a hospital visit where you couldn't be there.
During my non-parenting time, I was in Washington, and she had accidentally locked him in the garage with the car running for
Okay.
10 minutes.
He fell asleep in the car, is that right?
I don't know if he was asleep or awake.
Okay, and she didn't actually lock the garage. It was an issue with that garage door is sensitive, is that correct?
No,
Y'all have had issues with that garage door before.
there were issues, but that was not the cause of the garage being closed.
Okay, and did she act promptly and make sure you knew that it had happened?
I believe my mom called me first to tell me
To tell you about what?
what was that he had been locked in the garage.
Okay, is that because she called your mom for help, somebody come down there to help her get him out?
Yes,
Okay. And in your mind, did she handle that appropriately to get it done?
yes,
Okay. But you were in Washington and could not tend to your child?
during my non-parenting time, yes, I was in Washington.
Now, you agree with me, sir, at times, even after you guys came to court, she would ask you about the child's day and ask for details about the child, and all you would generally respond was, he's fine. Is that fair?
Yes.
Okay.
Well, when you say details, like, are you saying I didn't answer her specific question?
Yes, all you would say is, he's fine.
I think that I addressed, if she asked for a detail, I don't think I withheld that information from her.
Okay. This is on the 8th.
Hey, could you at least let me know how he's doing? It's really hurtful that you don't want to tell me anything. I'm a good person. I'm not crazy, even though you like to think that. I'm a worried mother. As I know, you know, after being with me for 12 years, I don't have a lot of trust in others to take care of my son. So when he's not with me, I just need more updates and reassurance. You know this about me. Can you please just work with me on that and understand it's not about you, it's about him.
Okay, and what was your response?
I said that he was fine.
Okay, that's the next part of the cumulative exhibit, Judge. Now, prior to the hearing on April the 2nd, 2025, the two of you had agreed that the minor child would go to an Easter egg hunt with the mother. Is that correct?
I think, wait, an Easter egg hunt?
Yes. Would do Easter with the mother.
Yes, in the parenting plan that we had informally agreed to prior to the temporary being adopted, we had tentatively said that he could go with her on Easter.
Okay. And when you didn't get what you wanted in court that day, or what you allegedly didn't want, you informed her that you would be exercising the Easter holiday. Is that correct?
Yes.
Okay. And did the child have to miss out on what the child usually does for Easter?
No, he did not.
Did the child miss out on an Easter egg hunt with the mother's family?
Yes, he missed out with the mother's family, but we did an Easter egg hunt at my parents' house.
Is there any reason why the child couldn't have just gone to that Easter egg hunt and come back to you?
We haven't celebrated Easter with my family since we had been together. So with it falling on my parenting time, I wanted to get to
Okay,
celebrate.
that's kind of my point. Traditionally, you guys had never celebrated Easter with your family, and it was more traditional to celebrate with hers, correct?
Yes.
Okay, and the child had always attended the Easter egg hunt with her family. Is there any reason why she couldn't have had 2 hours for that child to exercise that Easter egg hunt?
I don't know that 2 hours was the request.
On April the 14th, ask you.
How was Bryce this morning?
Okay, did you respond?
No,
Okay, when did she follow up?
at 5:55 p.m.
So some 8 hours later, she asks you what?
Wait, I'm sorry, what was the question?
What did she follow up and ask you at 5:55 after you had not responded?
She said, how is Bryce?
And what was your response?
He's eating. You want your call at when he's in the bath, probably about 6:30 or before.
Okay, if you'll hand that to Ms. Collins. Can you agree with me that that's how these conversations with Ms. Cuff went for some time?
Sometime. I think that shortly after, probably midsummer, I got better at responding and giving updates anytime that she asks. I think sometimes that I miss the fact that I get a notification. So messages that go unread. I also try to provide pictures when he's with me on my parenting time so that she can stay connected with what he's doing.
Okay, so on April the 15th, later, you don't apologize for missing the notification, you don't do anything like that. Were you intentionally ignoring it? Pardon me.
I'm not sure what I was doing at this time.
Okay, but you agree with me, sir, that you didn't respond and it took her 2 times asking you?
Yes.
Okay. If you'll just submit that to Ms. Collins. The exact same thing to her.
Yes, I believe these are all within the same time frame, for which this is something that isn't happening.
If you'll hand that to. Judge, if I may have a moment.
You may.
You pay daycare right now, is that correct?
Yes, ma'am.
It's $910 a month, is that correct?
Yes.
Okay, and what portion of insurance is for the child? Do you know?
I believe it is $364.
Okay, is that for you and the child or just the child?
That is just the child.
I may have a moment, Judge.
All right.
How many times have you rented a hotel room? Fiance?
I don't know that I've personally rented the hotel room.
Has she rented them for you?
Yes.
Okay, have you helped pay for them?
I don't think so.
Okay, how many hotel rooms have y'all been in together?
I don't know an exact amount.
Okay. Has the minor child ever been in one of those hotel rooms?
He is not.
Ms. Roberts?
All right, yeah. And I questioned you, and Ms. Duke had every right to cross-examine you. You had an affair on your wife.
That's correct.
You continue that relationship now.
Yes, ma'am.
Your girlfriend is now turned into your fiance?
Yes, ma'am.
Was your girlfriend married at the time that your relationship started?
She was.
Is she a jealous individual?
Not generally.
Okay. Well, some of these text messages that they've done, what business of it is yours, of your girlfriend is, if you're having conversations with the mother of your child?
I'm not sure.
Did you ever tell her and say it's none of your business? You know I'm married, you know I have a child? Did you ever tell Miss Ashley that?
No, I did not say that to her.
Why?
I don't have a good answer for that. I just didn't.
You left to go be with her when it wasn't your parenting time, correct?
I did that on 2 occasions prior to the temporary parenting plan, and since that moment, that has not happened. Aside from them, the Gammy and Pop Pop, and me running errands within the first right of refusal.
So all of these things about when you flew out and you did this, and there's a lot of conversation that's gone on direct examination. On how many occasions have you flown to Washington State since you started a relationship with Ashley?
I don't have a count for that.
Did you go every weekend, every other weekend that you didn't have your child?
I did. I went every week until she moved here.
And when did she move here?
October 21st, I believe.
You developed a relationship with her children.
I did.
Do you want her to develop a relationship with your child?
I do.
Are you capable of setting boundaries and saying that your relationship with your ex-wife is really none of her business?
Absolutely.
Obviously, she has trust issues with you. Ashley.
Yeah.
But do you also understand that she cheated on her husband?
Yes.
Do you have the same trust issues with her?
Not now.
Okay. Are you going to allow this lady's trust issues to interfere with your parenting of your child?
No, and I have not.
Was there discussion about you ever leaving and moving away and leaving your child here?
Not leaving my child here. There was a discussion about who would live with who, but ultimately it was the only option was for her to move here.
Who is your priority?
Bryce.
Has that ever changed?
That has not changed.
What allergy testing did you miss?
I missed one allergy testing. I believe it was possibly the second round. Again, it was during a period of time where it didn't feel like we could be in the same room and that be a good environment for Bryce.
Okay. But you left to go to Washington.
Yes.
Now, tell me about this carbon monoxide issue.
I got a call from my mom frantically on July the 4th, where Kayla had called her very emotionally disturbed, like upset, and Bryce was locked in the garage in his car seat, strapped in his car seat. It's a large vehicle. She had a Jeep Wagoneer inside of the garage, and she was locked out of the house, and she couldn't gain access to the house or the garage, and the garage door had closed. The thing was, essentially, we had it set up to where the garage door would automatically close every night at 8 a.m. And basically, the garbage can was at the road, and Kayla left Bryce in the car with it running, strapped in his car seat, and walked to go get the trash can from the road and bring it in. When she got to the end of the road, she didn't realize what time it was, and the garage door automatically closed, locking him inside. She was not able to get the front door unlocked, so she called my mom, who then called me while she ran to a neighbor's house that was an ex-firefighter from California, and he came over and was able to gain access through the back door and get to Bryce and get him out of the car. And then after that, she called me and was she was very upset. I think she had my parents take him for a moment to ride him on the golf cart while that she had emotionally calmed down. And then I had a discussion with her on the phone where she was reluctant to want to take him to the ER. She said it was fine, and I urged her to take him to the ER, and she did. And she called me on the phone while they were there, and then the rest I'd already talked about with the testimony with the discharge instructions and such. But yes, he got locked in the garage.
And that happened this past in July 4th in 2025?
Correct.
And do you think she did it on purpose?
Of course not.
It scared her, didn't it?
It scared both of us.
Well, where were you?
I was in Washington.
Okay. But have you ever used that event that she caused that could have resulted in the death of your child as anything against her?
No.
Would you even consider doing it?
No.
It was an accident, wasn't it?
It was.
But yet, because you didn't go to an allergy testing, you're less of a parent than she is.
I don't believe that's true.
And because you've gone on with your life and found somebody else in your life.
Yes.
And you didn't run back into court and seek some emergency custody because she could have killed your child, did you?
I did not.
You think it reflects badly on her as a parent?
I think that it's representative of how fast that a child's life can be taken. And it's a scary moment, but I don't think that means that she's a bad mother.
And y'all have continued this schedule, correct?
Yes.
I believe that's all.
Thank you.
Ms. Duke?
You agree that she didn't choose to lock your child in the garage door, did she?
She did not know.
Okay. But you chose to go outside your marriage and spend time away from the home, correct?
Yes, I had an affair.
And she repeatedly asked you to help her get that app on your phone so she could control the garage, correct?
No.
And you guys never got it installed on her phone in order for her to have the app to open it?
Are you talking about prior to me leaving?
Yes.
Oh, I don't recall if it's possible that we talked about getting it installed, but it wasn't a priority until.
And you set up that garage where that it would close at 8 p.m., didn't you, sir?
Yes.
And then you walked out on your wife and were not living in the marital residence of your own behest, setting up your own apartment, and left her to have to deal with that if it ever did get shut. Yes or no?
That I left, that the garage door still closed at 8 p.m.?
Yes.
Yes.
And she had no control over that, did she, sir?
I mean, technically, yes.
How did she have control over it, sir?
She could reset the garage door opener.
Did you ever show her how to do that?
No, I would have to look it up myself.
Mr. Cuff, your
Yes, sir.
wife's a fairly young woman by my standards, both of you.
They sold the house, and again, I could just ask him one question if you want.
Just have a seat. She's going to ask you a question. Let's get it on the record.
Know why you're now ex-wife or not?
I don't know. The battery, I believe, was taken out of it, but I don't know why. It did have a keypad. For the garage door? Yes.
Got possession of the door?
Yes, ma'am. Yes. Yes, I think we both would have had to read the instructions. Yes. Yes. No, she did not ask me to do that.
Sir, she asked you to help her download that app, correct?
Yes.
And you didn't do that, did you, sir?
Help her?
Download the app, correct?
Yes, we never downloaded the app.
Okay, that's all.
Well, hold on, I do need to correct that. After the incident, we downloaded the app and she got signed in with no issue. It took 10 minutes.
You finally transferred ownership to her, correct?
No, I did not.
That's all, Judge.
How do you download an app for the record?
Go to the App Store and search for, I think it was MyQ was the name of the app, and just download it.
You know why she needed help to go to the app, to open up a cell phone and to go to an app store?
I don't think downloading the app was a priority at the time.
Okay.
Is why that it.
And exactly, she could have done it. She could have changed it, done anything. It was a mistake. It was a tragic accident, wasn't it?
That's correct.
And have you blamed her for it?
No.
But now it seems like she's blaming you.
Yes.
She just believes you're a terrible human being.
Yes.
But do you have concerns that a woman that can't even open her cell phone and open an app has the capability of caring for a child?
I don't have concerns about her caring for a child, I guess, but I guess I feel like she could have probably downloaded the app.
But she wants I'll stop there. Thank you, sir.
Told you she couldn't get it connected. Is that correct? The app was downloaded, but she couldn't get it connected to the Wi-Fi at your house. Is that correct?
The Wi-Fi should have been connected through the phone.
That's all.
Thank you. You may step down.
Your Honor, Ms. Duke and I discussed this prior to the break. Do you want to go on and hear from the parties first?
Might as well, I guess. That's usually right.
Lee
This-
Jackson, standing in for Todd Jackson.
All right. Well, this is the Thomas Bartholomew Brennan versus Justin K. Chase case, and I show there's a motion to withdraw filed by Mr. Jackson.
Yes, Your Honor, that's correct. It's my understanding that the parties have reconciled and that Mr. Jackson's client, Ms. Chase, has relieved him of his services.
All right. Any objection on that in the courtroom? No objection voiced, so the motion of withdrawal is granted. Thank you. Appeal submitted in order, please.
Thank you, Your Honor.
This petition to open probate and to probate the estate in solemn form. And it shows that our notes in the file indicate we need the original will to be submitted. Right, we'll put it in the file. All right, so your clients are Malcolm Jeanette and Russell Jeanette, and they are seeking to be appointed as the co-executors under the will, correct? Well, then I will approve, that appears to be in order, so I'll approve that petition. You want to submit an order? All right. Well, let's go ahead and put them on since it's in solemn form. I wasn't sure if you didn't have them up here with you. Call up your witnesses. Let me see that back. Both of you raise your right hand. Let's place you under oath. Go ahead, Mr. Hubbard. Is that microphone on at the podium?
My name is Barbara Toone, Toone.
My name is Steve Hayes.
I did. Yes. He did. No, sir. Yes, sir. He was.
All right. You've proven your case, so I will admit it to probate. Thank you. Any time estimate? All right. Let me run through the rest and see what we've got. You're going to be behind the hearing that the first contested matter we're going to take up is the Cuff versus Cuff, and that's Ms. Duke and Ms. Roberts. The estimate is for a half day, so if you'll have time to discuss it during the breaks.
Yes, Judge, thank you.
All right, call the next case. You're going to what? I'm sorry. She's in the waiting room. Are you, Mr. Bellmeyers had been requesting to move it to 1:30. Are you prepared to stand in for him? I don't care. Just gonna, if it's at 1:30, you're gonna be behind whatever we're doing.
We can take it up now. My client's here.
All right. Ms. Huey, you are here today, and my understanding is that you have filed, again, representing yourself pro se in this case as well, that you have filed a series of motions, one of which is to establish a buyout procedure, authorize a transfer of interest, and to impose deadlines, motion to compel responses to requests for production of documents.
Yes, sir.
I'm going to allow you to have an opportunity to argue your motions if you want to address the first one, which is the motion to establish buyout procedures.
Yes, sir. Your Honor, I'm seeking disentanglement and finality in exiting this ownership relationship. I've been displaced for nearly a year and continue incurring approximately $2,500 a month in housing costs while my equity of over $250,000 remains tied up and the timeline continues to expand. I'm requesting a structured path forward that allows resolution rather than continued expansion of timelines and uncertainty. The current processes involve multiple personal property auctions while the real property, the primary asset, remains without defined listing timelines or endpoint. I'm simply requesting a structured buyout process and the ability to transfer my ownership interests with successor recognition so a purchaser may step into my shoes without disrupting proceedings or prejudicing the proceedings at all. I also have a 13-year-old child, and the prolonged uncertainty is directly affecting my ability to provide stability and move forward.
All right. This is a case that the court has heard motions in before, and I think there's already an order down that ordered that the property be placed for sale and that it listed the method by which we're doing it. So you're actually asking me to change the prior order of the court, but so far all I've heard is you're asking to set some sort of structured transfer process that would be more expeditious, but how exactly are you proposing that be done other than by selling the property by realtor?
So Judge, I'm asking that if I'm able or if I have the opportunity to sell my interest to an investor or third party so that I may exit the structure and the structure that you set forth for selling the property can continue and someone simply step into my place.
Well, I don't think there's anything that would prevent you from selling your interest to a third party, but the third party would have to be advised that there's ongoing litigation and that this case has already been, this is a partition suit, which means that owners of property that no longer wish to be co-owners of the property have an absolute right to partition the property. There are two methods by which the property can be partitioned. One is by partition in kind, where you divide the property up equally in value, and real property is oftentimes very difficult to do that with. This is a house, is that correct?
It is a house.
Yes, sir.
So it's very difficult to arrive at a partition in kind, which means the only other way is by selling the property. You have an interest in the property. If
Yes,
you
yes.
want to sell your interest to a third person, then you can do so, as long as it doesn't complicate or restrict what happens in this case, because we already have a court order that sets in motion the sale and liquidation of this property.
Yes, sir. Thank you. I just wanted clarity from the court that that process would be allowed and that those successor rights could pass.
let me hear from Mr. Osborne, who represents the other parties. Mr. Osborne, you may need, the prior person was a little shorter than you are, so.
Thank you, Judge. Your Honor, Ms. Huey's got multiple motions that she has filed before the court, so I'll address both the motion to establish the buyout procedure as well as the motion to authorize the transfer of interest that she has filed. Judge, as you have rightly pointed out, the court heard a prior motion in this matter on February the 12th of this year. During that motion, which was a motion to authorize the auction of the personal property as well as the listing of the real property, the personal property being auctioned with Mr. Neil Trice and the real property being listed for sale with Ms. Beth Thornton and Ms. Carrie Carrington as co-agents. Now, at that time, Judge, there was no opposition stated by Ms. Huey. In fact, everybody announced that they were in agreement with this proposed course of sale. That order entered. It became final. There was no opposition, no appeal filed to that order. We would just ask that that order be left in place, that the process be allowed to carry out. I did speak with Mr. Trice this morning. He said the first auction of the personal property took place this weekend. He said that it went very well, had a great turnout. Several items were sold. The second auction of the personal property is scheduled for July 11th, I believe, this summer. Once that is taken care of and the personal property auction is completed, at that point, Ms. Carrington and Ms. Thornton can proceed with getting the property listed. Respectfully, Judge, we would ask that the parties just maintain the status quo and allow this sale to go ahead and take place. Marketable title has got to obviously include any co-owners signing off on the listing agreement. Ms. Huey had previously indicated she was fine to list the property with Ms. Thornton and Ms. Carrington. They've both spent a decent amount of time, as I understand, going out, viewing the property, making recommendations on what needs to happen for showings. So we would ask that, again, the court just allow the existing order to stay in place, that the parties not make any transfer of the ownership interest, and that whenever this personal property auction takes place in July, parties can then immediately list the property with the agents, and hopefully it'll get sold pretty quickly. This is in a good area of the county. It's just off Spencer Mill Road. That area has historically done very well, especially here in the recent few years. I think the property will do quite well, but again, Judge, we would ask that the process be allowed to play out as set forth in the February order.
All right. Ms. Huey, the problem is that there's already an order down that establishes how this property is to be sold and liquidated and how the partition is to go forward. And that order went down and more than 30 days elapsed from the entry of the order. So therefore, under the rules, that becomes an order that's a final order. As a result of that, I am not going to make any changes in that procedure because of the fact that making a change in it would simply delay the process that we've already entered into. And I think that the process that we're engaging in right now is the best and most efficient way to liquidate this property and to try to obtain the best and most valuable price for the property for all concerned. Now, Mr. Osborne raises a point because Mr. Osborne's firm deals with title searches and so forth, and he's well aware that while I indicated that there was nothing that would prevent you from liquidating your interest and transferring it to some other party, the problem is if you were to do that and it were to interfere with the transfer of the sale of the real property because it complicates the title, then by allowing you to liquidate your interest, it complicates and restricts and makes more difficult and more expensive that interest that the process that we're engaging in to try to liquidate this property. For that reason, I am ruling that the prior order of the court as far as how this property is to be sold is going to be the order of the court that will take full force and effect, and that there will be no changes and that no party will be allowed to transfer any interest in the property until such time as the real estate property is, in fact, under contract to be sold. What that does, I think if we have an auction of the personal property, then the real property becomes much more marketable, and then I think that you'll see that there's a much better price of this. I understand your economic situation, but your economic situation does not require the court, unfortunately, to restrict the rights of the other parties that are involved in order to perhaps aid you in your situation would be detrimental to the remaining parties of this lawsuit. And for that reason, I cannot grant your request to allow you to liquidate your interest or transfer your interest to some third party that would then complicate the transfer of title at the sale of the property. There is a motion to compel responses to requests for production of documents. Is there?
Judge, if I could just address that briefly. This is Ms. Huey's second set of discovery requests that she has sent to us. She does have a set of discovery requests from us that still needs to be sent. The pending discovery from us includes a set of requests for admissions. Her second set of requests for admissions, I believe that was 95 that she sent on the second request.
95 requests for admission?
Yes, sir. That she sent to us. We have coordinated with Mr. and Mrs. Sproles. We've compiled answers to those. We had made efforts to get those executed electronically via DocuSign. Mr. and Mrs. Sproles were having issues with their email. Ms. Huckabee, one of their other daughters, who is also their attorney in fact, has met with me this morning right before court. She has executed those requests for admissions. I will be getting those over to Ms. Huey following court today. There is also a pending set of requests for production of documents. Judge, this is a rather voluminous file. That box contains all the documents we are trying to go through and compile, but again, given the volume of documents, we have not been able to get those over yet. We anticipate getting those done in the upcoming weeks. Mr. Belmars did file a response proposing a scheduling order if the court thinks that's necessary. But again, the other set of discovery requests, we intend to get those out to her as soon as we can.
Well, Ms. Huey, your request for production of documents, the second set of production of document requests that entailed 90 some odd, there is a point where both sides have the right to obtain information that's necessary in preparing their case for, excuse me, for a hearing. But there is a point where the court finds that the discovery process can be abused. And as a result of that, I'm going to give the petitioners 30 days to respond to your discovery requests. And if they have an objection to it, then they may do so. Any further discovery requests, if Mr. Osborne and the petitioners find that that is excessive, then they will be able to file a motion to quash those discovery requests. Discovery requests are intended not to be punitive in nature. They're intended to allow you to obtain information. But 90 some odd requests for admissions, or a request for admission is just basically saying you admit that the following to be true or false, or deny it. And it's oftentimes used in a method to try to force the issues, but I am of the opinion that 90 requests for admission, is that what they were, requests for admission?
Yes.
May be excessive under the rules, but in any event, we'll give them 30 days to file a response and either object or provide the information requested.
Your Honor, if I may, I just want to clarify, they were not meant to be excessive. They were directed toward issues that the plaintiffs themselves had placed on issue, including offsets, reimbursement claims, property expenses, accounting issues, ownership issues, and factual assertion. So I was simply seeking clarity. I was not intending for them to be overbroad or excessive.
All right. I'm not saying that they were excessive, but I'm just saying that there is a point where you become, it becomes excessive when you're in a discovery process. So just be careful to make sure that that doesn't arise. And Mr. Osborne, being the good lawyer he is, will file an objection to them if he believes that it has become excessive. All right. Then 30 days to respond to the discovery responses. The court finds that the motion to establish a buyout procedure, authorize transfer of interest, impose deadlines is denied.
Thank you, Judge.
Thank you, Ms. Huey.
Thank you.
Good morning.
I represent Mr. Lestoff in this divorce that was filed on March 12, 2026. Subsequent to my being engaged by Mr. Lestofka. I filed a couple of motions. They are set to be heard on the 26th. Mr. Holly came in on last week, I guess, and is now representing the wife. He filed a couple of motions. He set those for today. Unfortunately, we were not able to agree to continue them to the 26th. I'm asking that the motions all be heard on the 26th. Please.
Your motions were already filed,
Yes, they were.
and they were set for the 26th?
Yes, Your Honor.
Then why would we not have everything on the 26th?
Judge, if I may.
You may.
With your restraining order was all based on an arrest. That arrest would be for. That being said, I can't get a visitation. I canceled the problem. I did that after I filed some of mine. Counsel here about really not being able to agree to reset.
Well, if there's an emergency situation, then that would be different, but it sounds like to me there's just a division, an opposition to it. It would appear to me that this case, already having been set by Mr. Parsley on the 26th, that any motions that were going to be joined would necessarily, unless it was an emergency situation, would necessarily have to be heard on the 26th as well. So I'm going to move it all to the 26th with the understanding that Mr. Parsley, your client, needs to understand that when we get to the 26th, if there's been a showing that there's been an unreasonable denial of visitation to Mr. Holly's client, that will be a factor that the court will consider in making the decision. So I expect there to be a cooperation with your client. If there is no basis upon which now to withhold the children, then she needs to be able to see the children. All right, we'll move them to the 26th.
Thank you, Your Honor.
Thank you, Judge.
All right, then that puts us back on our first contested case of Cuff versus Cuff.
Judge, it's ready.
Well, he needs to sign it, so. And I guess that's the signature line for the judge, but we'll hand it to me whenever we get to it. All right, Cuff versus Cuff. I need the file, please. This is for final hearing, correct? Either party wish to make an opening statement? So let me make sure I'm understanding. You appeared before Judge Turnbow and entered an agreement to resolve the grounds for divorce and the property, and then you shifted the custody decision over to me. That's pretty much what happened. But I know Judge Turnbow's in his office today, not dressed for court, but, I didn't know if you needed him to come in and hear it.
Now, Judge, I don't know that it matters being dressed for court. Y'all have your robes on, so it's up to yours. We were set here on we came before the court, and Ms. Duke and I were able, the house actually got sold. We got a contract on the house. And as a result of that, that enabled us to kind of get the property issues resolved because there was a contract on the house. And so that's what we did. We ended up, both parties wanted a divorce. We agreed the wife would be awarded divorce, and then divided all the assets. So that left only the custody determination to be made. Previously, I was not originally the counsel that filed this petition, but there was a pendente light order that was entered back in April of 2025. And again, Judge Turnbow, as my understanding, that it was that they announced an agreement at that point in time. Ms. Duke, wasn't that correct?
That's accurate.
It wasn't a hearing. Judge Turnbow was the judge presiding there, but there wasn't testimony at the time. The parties were able to reach an agreement, and then they went to mediation and were unsuccessful.
I don't care if,
So-
I mean,
Yeah.
all I'm saying is you had everything else in front of Judge Turnbull and you resolved it. I wasn't sure exactly why this custody issue wasn't,
But
you
you
know,
were
heard.
Because you were the next one in line.
That's fine.
That was
And-
it.
and I'll be
There
glad to
was,
hear it.
there wasn't any testimony on the Pendante Light hearing that would necessitate going back, and it was just the fact that we settled it when Judge Turnbow was here last month, and so you had an available time. So we
Right,
said,
that was the April 7th, 2025 Pendante Lighting motion, order rather. All right,
yes, sir. And that's what the parties have been going by. Your Honor, these parties, again, as we said, we stipulated grounds for divorce. They've been declared divorced. The parties have one minor child, Bryce, who will be 4 years of age come this September. At the time of the separation, the mother remained in the home. The father moved out in an apartment. Mr. Cuff filed for divorce, and he filed a parenting plan where he was asking for an equal residential schedule, 182.5 days each. They came to a hearing and announced an agreement wherein the mother was designated as the primary residential parent, the father was designated as the alternate parent. And the father, they split the child, although not on an equal basis, but pretty close. The father had the child from Friday at 3 until Thursday at 7 a.m. when the child would be dropped off at daycare. And he did that every other week. And then on the alternate week, he had from Sunday to Tuesday. So effectively a 2-4 schedule with the father. As I said, Mr. Bryce will be 4 years of age come this September. My client works as a in the software industry and works from home. He has kind of a unique schedule wherein that he works a lot of evenings because he deals with foreign customers, and he has to keep that schedule so he's available effectively to be there for the child. The mother, as I understand, works a split 2 days home, 3 days at the office schedule with more traditional hours. Both parties are capable parents. Both parties loves the child, and this is just a unique situation, Your Honor, where they can, a 50-50 schedule would be appropriate. My client is asking to be designated as the primary residential parent, and we would ask, and the reason for that, Your Honor, is effectively that they would have joint decision-making, but if somebody had to effectively make the decision, he would ask to do that. Both parties have provided the day-to-day caregiving of the child, both capable and able-bodied to do it, both have jobs that lend themselves to be able to have a 50-50 residential schedule. And again, Your Honor, that's what we're requesting.
when you say a 50-50 schedule, what are you?
Well, Your Honor, at the time, the schedule that Mr. Cuff, when his previous attorney, Ms. Lowe, was practicing, he asked for a split from a Friday to Tuesday and then a Saturday, but again, the week-to-week, he's about to be 4 years of age, and I think a week-to-week schedule would be appropriate. If the child was any younger, again, possibly where the child doesn't go 7 days without seeing either parent. But I think in this situation, a week-to-week schedule, or in the alternative, a 2-5-5-2 schedule would be what we would be asking for, such as he would have, as I understand it, Ms. Cuff has 2 days she works remote and 3 days that she is in Brentwood where her employer is. And so again, designating if she has those set days that he would have, again, effectively Monday, Tuesday, she would have Wednesday, Thursday, and they would alternate the weekends. So it would effectively be 2-5-5-2 if you wanted to do something less than a week to week. So those are the two schedules that we would propose that would be appropriate for Bryce. And again, what goes along with it, there hasn't been any indication through discovery that either party intends to relocate outside of Dixon County, but we would request that Dixon County be designated as the school that the child goes to. Again, within Dixon County, there's several different, whether they're Charlotte, White Bluff, or Dixon or Burns. Again, we would ask that Dixon County be designated as where the child goes to school.
Duke?
Your Honor,
The rule? Rule has been requested, if there are any witnesses other than the parties that need to go outside and remain outside until you're called to testify, you're not to discuss the testimony of any other witness until you yourself have concluded your testimony. So. All right, anybody that's going to be a potential witness? All right, go ahead.
Judge, what Your Honor is going to hear today is that the mother has always been the primary residential parent, making sure that this minor child is cared for. When Ms. Roberts stated what the current schedule is, it was a little off. I think she just misspoke regarding one of the days. The current schedule is Friday to Tuesday and Sunday to Tuesday. So it's a 3-2 split. And I would submit to the court that when that schedule was established, it was established with the parties' work schedules in mind. I would submit to the court that the father, I think he's quite bold in asking for primary residential parent in that he has completely thrown his marriage away with a paramour wherein he was repeatedly leaving this minor child for the mother to take care of, which was fine with the mother, and flying across the country for an internet sex hookup. And as I understand it, Mr.
An internet sex hookup?
Yes, Your Honor. He met a
According to the file, you're saying it was Washington State that he was going to?
Yes, Your Honor. And he was flying there routinely, specifically when the child had a overnight stay at the hospital. Father took off and went on to Washington State instead of sticking around to find out if the child was okay. Father has left the child, I wouldn't say neglected. I'm not going to say that he is a bad father, but he has chosen sex and a girlfriend over his minor child. And that does put him in a questionable light as far as this court is concerned regarding his ability to care for the minor child. I think the court's going to have to glean from some of the things that Your Honor hears today that he's quite deceitful about his time with the minor child and when he's actually exercising his time. We built into the temporary schedule a provision wherein if the father was not going to be with the minor child for a period of time, that he would contact the mother to allow the mother to have the child. Proof is going to show today that repeatedly he, during visits, has gone to the gym and spent more than 2 hours there with his girlfriend watching over him while he's there. The girlfriend is the internet sex hookup, now girlfriend, maybe fiance. He's been wearing a ring, though I'm not sure he's got it on today. Your Honor's going to find that he was required not to have the minor child around the girlfriend, fiance, whatever she is, but he has routinely video gamed with she and her children, and the minor child has been exposed during this time period. He's had difficult time following the court's orders. Court's going to find that he would leave early in the morning at like 4 a.m. to go work out at the gym, leaving the mother with the burden of caring for and getting the child up for daycare and getting the child to daycare. I will say he did pick the child up from daycare routinely, but he cast his family, including the minor child, aside for this woman in Washington. I think the court's going to find that when he could exercise time with his child, he chose to go to Washington instead of being with the child. So that's the crux of the case. We are going to need to calculate child support today. Your Honor is going to have to rule on visitation. We are asking that based on the agreement of the parties originally for what would work best for this child, that remain the case. I think the mother could come before this court today and ask that he just get an every other weekend schedule, because frankly, I think that that's what he wanted on the front end, but was pressured by his family to ask for something different. I think his text messages are going to show that. The text messages, I will say also, the text messages show that he specifically, when he was cheating on his wife, made arrangements with the girlfriend saying, I can't come to Washington until I have a custody order in place. And so he was being manipulative of this court. He was being manipulative with the wife. He was being manipulative with the child in order to try to get what he wanted custody-wise. Your Honor is going to have to consider that there are daycare expenses involved in this matter, and we're asking for the mother to be able to make all the decisions, or at the very least, make the final decision with regard to decision-making.
All right, Ms. Roberts, you may call your first witness. Yeah. I've read through the file. The file shows that it's Friday at 3 p.m. to Tuesday at 7 a.m.
Yes, it's
when the
morning.
father drops a minor child off at daycare every other week. And then Sunday at 6 p.m. to Tuesday at 6 p.m. on the alternate week.
That's correct. And so it'd be a 3.5-day, 2-day.
Judge, I think the bailiff went back and informed you that Ms. Duke and I waived closing.
Are you planning on calling any other witnesses?
No, Your Honor, we rest, and we are going to waive oral argument and ask Your Honor just to rule.
We are giving Your Honor time to, if you need.
Do what?
We were giving you time in case you had to collect your thoughts in the back before you came back in.
Collect my thoughts. That's a good one. Well, let me talk to your folk for a minute, and I'm going to address this to everybody in the room. Too often in divorce cases, especially where custody is involved, we spend an enormous amount of time, an inordinate amount of time, picking at every little thing that we can about the other party to try to make them look as bad as possible, because we're fearful as lawyers. We're fearful that if we don't bring out all the negatives, then, we won't get a fair shake. In this particular case, I think I have two good parents. I think I have, admittedly, a father who loves his son, and I know I have a mother who loves her son as well. That doesn't mean that either one of them is perfect or has failed, or that has demonstrated sterling behavior that would indicate that they have never done anything wrong as a parent. Both of them have made mistakes. Some of those mistakes are more understandable than others. But it is this court's opinion that both of you are good parents. Now, this decision that I have to make is based upon the law and the facts that have been presented to me. And you've asked me to make a decision regarding who should be the primary caregiver for the child and what should the schedule be. You two have agreed upon a schedule on a temporary basis, but now you're asking to adopt a different schedule. And I'm required to determine first and foremost who is the primary residential parent in this case. I'm required to look at the statute that I'm dealing with is 366106 of the Tennessee Code, which basically gives me a set of factors that I have to consider in determining who should be the primary residential parent. So I will go through those because the Court of Appeals is always wanting to make sure that if this matter were to go up on appeal, they always want to make sure that I have considered and weighed those factors in making my decision. The first one is the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. I think this is a situation where both of these parents, I think, have a stable relationship with the child. I think both of them love this child very much. And if I would probably say that the mother has performed the greater responsibilities for the child, although the father is not heavily slanted in favor of the mother, because I think the father has also participated in that, at least during the time that they were married. Each parent, so I would say that that's an equal factor for both. Each parent or caregiver's past or potential for future performance of parenting responsibilities, including the willingness and ability of each parent or caregivers to facilitate and encourage a close and continuing parent-child relationship with the child and both of the child's parents, consistent with the best interests of the child in determining the willingness of each of the parents, well, going through the entire statute. Basically, that means I have to look to see whether each of you has been, has the potential to ensure that the other parent has a good relationship with the child. And I think both of you are somewhat deficient in this particular regard. I think that Mr. Cuff has demonstrated that he has lost sight of his primary responsibility towards this child and has set aside some of those responsibilities. And I think some of the text messages between him and Miss Ashley have demonstrated that there was a lot of planning going on about how to get around his wife knowing what was going on and his get around how the child could be taken care of and so forth. But I also think that Ms. Cuff is at fault in this responsibility too. I mean, the things that you have done in this situation and said and done are regrettable as well. But I also understand you're operating from a feeling of betrayal. And, it's, as Ms. Roberts says many things, but one thing is she doesn't cut a lot of slack to her own clients, and she cross-examines them in a way because she brings out the negatives that they have before anyone else gets to do it. That is a good lawyer's tactic. When you know you've got a client with problems, if you address it on the front end, then it lessens the sting when the other side gets to do that. So Ms. Roberts has brought out on her examination of Mr. Cuff many of the very regrettable things that he engaged in. When you get married, it's supposed to be for life, is what they say. I know that's rarely ever the case now, but still you make a commitment to someone, and when you violate that commitment, it becomes a very difficult thing to get past. That's what's happening, that's what has happened with Miss Cuff. I made the comment earlier about if she meets someone down the road and he starts telling you how to operate how to behave with your child, that you're not going to like that very much. But it's likely that she's going to find someone in her life that she will want to share it with. She's young, and I think she will certainly find another way. But Ms. Cuff, that's the other thing I would point out to you. Life doesn't end with this divorce. You're a young person, both of you are. You have a lot of life left. You've got 15 years left in your child's minority. But anyone, both of these lawyers and myself, can tell you that your parenting of your child does not end when they turn 18. You will continue to have to provide for it and so forth. So I'll get to the rest of that speech in a minute. But I think that both of you have been somewhat deficient in trying to jockey around for the purposes of this hearing as far as promoting a good relationship with the other one. And while it's understandable about the things that you attempted to do to save your marriage, that is unacceptable when your child is involved. The one true innocent in this case is your child. You know, he's 3 years old. He deserves to have a good relationship with both of his parents and not one that is slanted towards one parent or the other, or the parent tries to influence the child against the other parent. Refusal to attend a court-ordered parenting seminar, I don't have any indication that either of you have refused to do that, but both of you haven't, you'll need to do that within a period of time afterwards. The disposition of each parent to provide the child with food, clothing, medical care, education, I think we both have been willing to do that, and I think it's a situation where perhaps Mrs. Cuff has been the one who's primarily made the doctor's appointments and taken the child to the doctor, but Mr. Cuff has participated some in that. So that probably factor would favor her. The degree to which each parent has been the primary caregiver, and I think that I've held that both of you have taken responsibility, but I find that favors the mother. The love, affection, and emotional ties existing between each parent and the child, again, I have no question that both of you love the child. Mrs. Cuff has focused her entire thought about this on the child and, to an extent, her feeling of betrayal by Mr. Cuff. Mr. Cuff has focused on his love for his child, but also extended that to a new relationship that he's gone into, and therefore he has left the child behind on many occasions when he could have been with the child and to pursue this new relationship. That's his choice. but I find that a factor would favor the mother. I don't have anything other than the emotional needs and developmental level of the child. I don't find that to be any evidence other than you've got a typical 3-year-old who seems to be doing well. Number 8 is the moral, physical, mental, and emotional fitness of each parent as it relates to the ability to parent the child. Again, neither of these, parents is without fault in this regard. Clearly, Mr. Cuff could have handled his separation from the family in a better way. He chose to basically break his marriage vows and to go into a relationship with another woman and to hide that from his wife. And as a result of that, I think that has necessarily caused Mrs. Cuff to react in negative ways. So while this factor could be applied to both of them, I find that factor is favoring the mother because while she has not been without fault, she has not engaged in an extramarital affair, and therefore that factor would favor the mother. The child's interaction in her relationships with siblings, other relatives and mentors and so forth, I don't really have a lot of evidence about that. The importance of continuity in the child's life and the length of time the child has lived in a stable, satisfactory environment. Clearly, I think there's been some upheaval. However, I think that primarily the situation that they've entered into and been going on for a year or so has resulted in a stable environment for this child. Don't have any evidence of physical or emotional abuse to the child. The character behavior of any other person who resides within or frequents the home of the parent. In this situation, I would have expected to have heard from Mr. Cuff's fiancée, especially in view of the fact that Ms. Duke and her client were seeking to have a restriction against her continue after the divorce to prevent her from being able to be around this child. But I don't have anything other than some of the text messages and so forth to indicate anything about Ashley's situation other than the fact that she's divorced as well and has 2 children and has moved here from Washington to pursue her relationship apparently with Mr. Cuff. Reasonable preference of a child doesn't apply. The employment schedules of the parties. Mrs. Cuff works in Brentwood and she has a Monday through Friday job, although I think she says she has to go in only on like Wednesday through Friday. She actually has to be in Brentwood and she's available beyond that. Mr. Cuff has an unusual schedule and works from home because he's a software engineer. If I knew what a software engineer really did, I would understand your job a little more, but it sounds like to me that you're most of the time on a computer somewhere. So, but it does sound like to me that both of their schedules can accommodate any kind of care that the child might need. Whether either parents had custody or parenting reduced, I don't find that to be a case, and I don't find any of the other factors that are relevant. So, having considered all of those factors, it is this court's opinion that the primary residential parent of the minor child should be the mother, Mrs. Kayla Michelle Cuff. Then I have to move to the setting of a schedule. And this is the more difficult part. The parties agreed to a schedule at the time that back in April of 2025 that it was not an entirely equal schedule, but it was certainly more than every other weekend. And in that schedule, the father was having time Friday at 3 p.m. to Tuesday at 7 a.m. when he drops the minor child off at daycare, and that's every other week. And then on the odd week, he has Sunday at 6 to Tuesday at 6 p.m. on the alternate week. So he picks the child up Sunday, a Sunday night, all day Monday, Monday night, and then returns the child all day Tuesday, and then returns the child at 6 p.m. in the alternate week. That's not an entirely equal schedule, but it's pretty close. And as a result of that, this court is of the opinion that on a permanent basis, until the child reaches a certain age, and I'll deal with that, but right now we're going to keep that schedule going as is previously ordered. This child is 3 years old. He'll be going into pre-K sometime either not next year or the year after. And then after that, it's going to be kindergarten. Right now, I'll need to go through, and I don't have a parenting plan before me, but the day in, day out schedule will be just as what they previously agreed, and I affirm that to continue. On the spring, once the child is in school, we'll have to deal with it. And I'm going to go ahead and put an order down to hopefully keep them from having to come back. Once the child is enrolled in school, then the Dixon County school system yearly calendar will apply. In addition to that, the school breaks will be equally divided. Now, they can divide them 50-50. I think they've had 2 weeks in the fall and 2 weeks in the spring. They can divide that 50-50. During the summer vacation, right now, because the child is not enrolled in school, I'm nonetheless ordering that each of them have at least 2 weeks of extended summertime with the child. You'll have 2 weeks, they will be separated. So we'll just go ahead and say that you'll have a week in the month of June that you can do whatever you want to without having to worry about him. He'll have a week in the month of June. Your lawyers can decide which weeks you get, but he's going to have a week. If he wants to take the child to Florida, he can do it. And that's because he's his son and he's going to have that right. You will have the same right. And we'll go from there. He'll have 2 weeks, 1 week in June each and 1 week in July each, because school now starts in August, I think. Once school starts, they're going to alternate weeks. Once he's a school age and starts kindergarten and you're adhering to the school system, then he will have alternating weeks, so that during the school year, the schedule that you've been operating on will apply. When the school is out for the summer, it'll be alternating weeks. And this is about as fair as I can do as far as making, it's not exactly a 50-50 split, but it's pretty close to giving you what you want. All other holidays will be the same holidays that I have dealt with before, and I think the lawyers know that well enough to know that generally I'm going to be going, when you have the child for Christmas Eve and Christmas morning, the next year he has the child for Christmas Eve. If you two can't work it out, Ms. Duke and Ms. Roberts do a lion's share of domestic work, and they're both good lawyers, and they will represent you to the extent that they can, but they can also give you advice. So under the circumstances, they'll alternate the holidays under the usual schedule. If you run into a problem, you can get with me. Trying to think what else. I don't have a parenting plan to look at, but the next step would be to determine if there are any special considerations. The first thing, all decisions will be equal, jointly made, rather, with the exception that if the parties cannot agree, then they will be required to make they will have to have a discussion, and if the parties cannot agree, then the primary residential parent will have the final say. And that'll solve some of your problems about this T-ball stuff. I've been to T-ball games, I've been to soccer games for my grandchildren, and at this age, going to 2 games a day is a bit much. And I think that's probably something that needs to be avoided if possible. Let me look through this just to make sure I'm not omitting anything.
My client will keep health insurance, continue.
Pardon?
My client will continue to keep health insurance.
All right, he'll keep health insurance. We'll calculate the child support based on his income, which he testified was $145,000, and hers was 81, I believe, thousand.
We have those numbers.
Right, and I think you two can exchange current information. He's been paying for daycare.
He pays for daycare.
And
I'll
he's
tell
been
you
paying
both.
support too, like, we don't have to do back support or anything. He's been paying his support
Right.
since they sold the house.
Understand this. My grandchildren, 2 of my grandchildren go to Walnut Street Church of Christ daycare. And as a result of that, I'm a big believer in the daycare that they offer because it socializes the children. It gives them an opportunity to make friends. And while I don't think it's required that you have to go there every day, I still think it's a good idea to have that regular activity. So that's why I consider daycare expense to be one of those things that can be considered in that. Now, I guess that then brings us down to the issue of Miss Ashley, who may be sitting in the courtroom. I don't know if
She is.
Ashley's here in the
I asked her
courtroom.
to come in, Judge.
Judge, may I backtrack just 1 second? Can they alternate the child's birthday also?
It's the 22nd of the 8th of September, which the child is going to be in school, so it's difficult to do that. It's a
Look,
scenario, they're going to do the day after.
Let me just give you both some advice. There is no reason in the world that you can't get together and have a birthday party on the child's birthday and have both of you and your significant others be present. And if you want your child to grow up well-adjusted and to have an opportunity to know that his parents are both mature individuals, then you will understand that you're going to have to behave in a way that puts his best interest first. You may not like his new person you may not like Ashley. I have heard nothing that indicates she is a threat or harm to this child. Obviously, the circumstances under which they came to be together is regrettable, but you may have a new person in your life soon that he may not like very much, and he may think he's replacing me as Wright's father. The fact is, it's tough to him. If he didn't like that, he could have stayed married to you. So what I'm telling you both is you're going to have to start putting your child's best interest first and think about every decision you make interacting with the other parent about how it's going to impact your son. Because if you don't, if this animosity and this hostility continues and this gamesmanship continues where you try to manipulate things to help your advantage, if that continues, then you are going to ruin every major event in your child's life. Every birthday that he has to have separate birthday parties because his parents can't stand to be in the same room together, or their significant other, mom doesn't want to be or dad doesn't want to be around them. Every birthday, every major event, every holiday, every major event when he turns 18 and graduates from high school, both of you are going to want to be there. You're going to want to have a celebration for him. Why have to have two celebrations? Same thing goes with college education. If he goes off to college, Ms. Roberts can tell you, her son just graduated from with a master's in business administration. Ms. Duke's children are reaching that age. Having an opportunity for your child to see the two of you together and to see that you can be around each other and that there's not that type of animosity will be healthy for your child, and it will give them an opportunity to grow up and have as normal a childhood as possible. For example, he's going to get married someday, I'm going to assume. And when he does, both of you would like to be there for that wedding, I would assume. And if you can get along well enough, then he can have a great event. If you can't get along well enough, he's going to be worried about how mom and dad can't stand each other, and they're going to be fussing and fighting and ruin my wedding day. So think about things from that perspective and try not to use the child against each other, and try not to put him in that situation. For that reason, at this point, I have no evidence to indicate that Mr. Cuff's fiancee, if in fact she is his fiancee, is a person that should not be exposed to your son. And I will say this, that if it comes to this court's attention that there is some reason down the road, then we'll take appropriate remedial action at that point. I don't expect that to be the case, but right now I don't have any reason to believe that she would be a harm to the child. They didn't exercise good moral judgment, but by the same token, he's going to have a long life. He's going to have to get used to people who might be doing things that we don't all agree with. So for that reason, I am lifting any restriction against Ms. Ashley being around this child, and with the understanding that Mr. Cuff, your first responsibility is to your son, not to your girlfriend's or fiance's children, but to your son. And I can tell you that relationship you might have with those children can create animosity or heartache for your son if he feels like you're putting more emphasis and placing them above him. So you're going to have to keep that in mind and make sure that he stays to be your first and foremost consideration. I think you both can be good parents. I think you are good parents. I think you've just had a rough patch to go through. It is never a lot of fun to go through a divorce. Ms. Roberts and Ms. Duke and I practiced law in front of Judge Leonard Martin, and he used to describe going through a divorce is like taking off all your clothes and running naked through a briar patch. It just hurts all over, and it does hurt. You have a feeling of betrayal, and Mr. Cuff ought to be having a feeling of failure on his part. But under the circumstances, you can get past that, and you're young, you have a long life ahead of you, and you can, rally from this situation and find yourself in a better situation. I hope that's what happens for both of you. I hope you have a stable environment in the future, and that this will end your animosity and your problems that you have. I'm not naive enough to think that it will be without problems, but always try to remember that those decisions you have to make, put your child's interest first. Anybody have anything I didn't cover?
I just have a point of clarification, if I could. The current schedule will continue, and the summer vacation they get 2 weeks until the child goes to school, then they do week to week.
When the school schedule with holidays and spring and fall and all of that covered, except for I'm talking about not holiday vacation.
Yeah, I thought the schools.
The school breaks all come into play when the child enrolls in the school system as a kindergarten student.
The Tuesday, the same schedule as existence now, and he has every other week, he has Tuesday that he returns the child at 7 a.m. And just clarifying that the testimony is she goes into work at 7. She goes to work on Tuesday. Is there and the child is going to continue, does he still have an obligation when the child goes to preschool? The child's going to go to preschool starting in August, and I think the testimony was it's like a Tuesday, Thursday program, and it's a half a day. Will whose time on his one time he keeps till 6 o'clock on Tuesday, the other one is at 7 a.m. on Tuesday. Can we just do 6 o'clock on Tuesdays?
The children usually go back to daycare after that. They go back to daycare after preschool for the rest of the day. So
They have preschool for half a day, and then they are in basically playtime at daycare after that.
I'd ask that we
So-
keep it the same as the
So
temporary.
we just leave them
Well,
there.
but preschool doesn't start at 7 a.m. It usually
No.
starts at 8. So when he goes to preschool, can he just drop the child off when preschool begins?
They go to daycare first, but I don't know that 7 or 8, if he's got the child and he's dropping the child off, I don't think.
I don't think
she's
it
gonna-
matters if he drops the
That's
child
my-
off.
That's my point. As long as the child gets to preschool on time, are we hard and fast at 7 a.m. is my question, is what I needed a point of clarification.
Hard and fast between 7 and 8 a.m. is fine.
Okay. Good. Okay. And then when you did the 2 weeks, they're going to do the summer, again, he'll have the current schedule. Can we start it? Do we want to start when they have the week during the summer? What day? Do we want to run Friday to Friday, Sunday to Sunday?
My belief is Friday to Friday is the best scenario, because when they get to your house, and this is true, I think, in my opinion, if you were doing an equal week on, week off during the summer, whatever, he'll probably start carrying a bunch of stuff from your house to his dad's, and from his dad's to your house. And if you do it on Friday, he can get his stuff to your house, and then he's got the weekend to do whatever he wants to do before the week starts. So that would be my thought.
And again, that exchange time can be after school on Friday.
Okay.
When they start school, when they do, they'll just do the Friday after school.
At 6 p.m., she'll pick the child up, and then they exchange, so the child doesn't have to have his things.
Okay, I didn't know when the child starts school, whether we wanted to adopt it. And then the last thing to clarify is I just thought it would be easy, since it was testified in the hearing that he had the child on Easter this year in 2026. So we start our odd and even using the first we'll go from him having Easter in even years, and then we'll do the schedule around that. And that seems to be the holiday to start with, since that was the last one he had. Is that okay?
It's fine. I think we just need to look and see if there are any holidays that maybe she had that he would get instead. We just need to
Work it out. And if
That was-
there is a holiday that one of them had that under this new schedule would be again to them, then maybe they can share it. This would be part of the trying to work together that I talked about.
And-
Easter is one of those days where both of you want to see your child on Easter. So, you know, you ought to work together to let both of you have, if you give them an Easter basket or whatever, then let it happen and both of you get an opportunity to see your child. So
And then tax deduction.
as long as he's paying child support, and I'm assuming he will be paying child support, then as long as he pays current child support, they'll alternate year to year.
Who gets 26?
Who's claimed them last year?
Well,
They
filed
did,
joint-
they filed
jointly for
jointly.
2025.
She'll claim the first year.
She'll get even, you'll get odd. Because it would benefit both of them. They both make money to where, but they both need the deduction.
I gave you both all day to give you every opportunity to express your thoughts and to get this out of your system, because I think that's healthy. Mike, I hated it when judges used to cut me off as a lawyer and not let my client say anything, tell me what he was going to do, and then the client walks out and says, I didn't get to say, I didn't get my say. I wanted to give you your say. You've had your say, and I've made the decision. I didn't ask to make the decision. I would have been glad for Judge Turnbow to make the decision, but I did it the best that I could do, and I wish you both the best in the future, and I hope that what I've done will try to give you an opportunity to have your son equally co-parent your son as best you can. So,
Thank you, Your Honor.
all right, who is drawing the order?
I think between the two of us.
Ms. Duke and I have several orders that we're going back and forth that is due from us, so we will see which one gets to it.
We're going to have a Friday night order sesh. Take care of it.
All right, then with that, we stand adjourned.
Thank you, Your Honor. Okay, come on out here a second. All right.
She gathered that Chase has his child in Oxford weekend, so this
Yeah.
just coordinate with him.
I don't know which computer it is.
In this emotional divorce and custody hearing, a judge delivers a powerful message to two parents whose marriage may be ending, but whose responsibilities as parents are only beginning. After hearing testimony from both sides, reviewing evidence, and considering Tennessee custody laws, the judge explains that the case is not about determining which parent is perfect. Instead, the court's responsibility is to decide what arrangement is in the best interest of the child. The judge acknowledges that both parents clearly love their young son and have played important roles in his life. However, he also points out that both have made mistakes throughout the separation and divorce process. Rather than focusing on every accusation and grievance raised during the case, the judge emphasizes that the court must focus on the child's future rather than the parent's past. As the ruling continues, the judge carefully reviews the legal factors required by state law and ultimately names the mother as the primary residential parent. At the same time, he ensures that the father will continue to have significant parenting time and remain actively involved in his son's life. The judge explains that children benefit from having strong relationships with both parents whenever possible and approves a schedule designed to keep both parents involved as the child grows older. But the most memorable part of the hearing comes when the judge steps away from legal language and speaks directly to the parents. He warns them that if they continue fighting, manipulating situations, or trying to turn the child against the other parent, they will damage every major moment in their son's life. Birthdays, holidays, graduations, and even future milestones could become stressful memories instead of happy celebrations if the conflict continues. The judge encourages both parents to start putting their son's interests ahead of their personal frustrations. He explains that divorce may end a marriage, but it does not end the need to work together as parents. He reminds them that their child deserves to grow up seeing mature adults who can cooperate despite their differences. By the end of the hearing, the judge makes one thing clear. The real winner in a custody case should never be one parent over the other. It should be the child. What began as a difficult divorce dispute ends with a powerful lesson about co-parenting, maturity, and the lifelong responsibility of putting a child's needs first. Curiosity, do you think courts should prioritize equal parenting time whenever possible, or should one parent usually be designated as the primary caregiver? Like and subscribe for more real courtroom moments.